Today is our first class on constitutional law. The subject of constitutional law can be organized into two major categories. First, procedural con law, and secondly, substantive con law. Procedural con law is about whether or not you're going to get into the federal court system at all. And there are a number of reasons that you may not get your case into federal court. Substantive con law is about if you get into federal court, what do you have to say when you get there? And basically, there are two categories of arguments you might make as to whether or not the government, either state or federal, has violated the Constitution. The two arguments are, number one, did the government, state or federal, have the authority? Was it authorized to do what it did? And secondly, if it was authorized to do what it did it go too far? For example, the state is certainly authorized to promote health, welfare, safety, and morals of its citizens. One way to promote safety is to shoot everybody who runs a stop sign. That would stop traffic accidents or that type of accident, but obviously the government has gone too far. And so even though the government may be authorized to promote safety, did they go too far in that they invaded individual rights in the process of doing it? So once again, the summary is as follows. Constitutional law consists of two major categories: procedural con law, can you get into court at all? Substantive con law, once you get there, did the government violate the Constitution? There are only two ways for the government to violate the Constitution. Those two ways are either the government was never authorized to do what it did, and we need to look for the places where it gets its authority. You need to know about those. Was the government authorized to do what it did? And if it was authorized to do it, did it go too far in trying to do what it's authorized to do? And that's the essence of what con law is all about. Let's start with procedural con law. Now, procedural con law on a typical con law question on California bar exam is worth about 20 points. Probably 2/3 of the con law questions on the bar exam have procedural con law issues worth those 15 to 20 points. And those procedural con law issues can be summarized by this mnemonic here, jammers. Now, the diagram that you see on the board that lays out a visual image of this structure of con law that I just told you about, procedural, substantive, and the substantive into these two parts, authority and did they go too far. The diagram that shows that's on the board is in more detail in this Con Law What to Write book. In the Con Law What to Write book, okay, if you turn first in the book, there is the Constitution, and after the Constitution on page 2, there is this diagram. And this diagram is reproduced on the board, not quite in as much detail, but if you'd like to see it and work with it in this detail as I talk with you about it, please turn to page 2, and you can follow the lecture from the material on page 2 in the What to Write book on constitutional law. If you don't have the book, you can follow the diagram on the board pretty well, but there's a lot more detail in the book. Procedural con law, the issues can be summarized here by this mnemonic jammers. J, there are 3 A's, and so I have an A cubed here. M, E, R, S, S, 2 S's in jammers. Let's talk a little bit about each one of these. First of all, in the What to Write book, there is a paragraph or 2 or 3 about each of these. Right after, in the early pages, page 3, 4, 5, right in there someplace. So you can read about each of these. Let me give you an oral summary about them. J is for justiciable. in order to get into the federal court system, your dispute must be a justiciable dispute. What do we mean by a justiciable dispute? We mean it is a dispute that can be resolved by the courts, by the justice system. And in order for a dispute to be resolved by the justice system, there must be rules which can be applied, rules of law which can be applied to resolve the dispute. Now, if you have a dispute with your girlfriend or boyfriend about a date, there are no rules of law that deal with that. So it's not a justiciable dispute. Certain disputes, should we be in a war? There's not a rule about that. I mean, whether or not war was properly declared is another matter. But in terms of the social policies, etc., that led to the war, there are no rules that the court system can apply to decide whether or not we should be in the war. It's a political question. And so in order for a dispute to be justiciable, the dispute must be one that you can resolve by applying rules of law to the facts. There has never been an issue on the bar exam, on this essay part of the bar exam, dealing with the question of justiciability. It's almost a public policy issue and does not happen on the bar exam. The closest thing we've come to that is one case where Congress attempted to exclude a member of Congress from voting and being on committees and so forth because they didn't like something about this person. It was Adam Clayton Powell. And the Supreme Court said no, that if a person has been elected to act as their congressional representative, that the Congress itself, the other members, cannot exclude that person. And so that involves kind of a combination, something close to justiciability, but the court said that was a justiciable issue because there is a constitutional rule about how you get your representatives elected. And if the person was elected, then that's the end of it. The other elected members cannot exclude the person from functioning in the court system, in the congressional system. So this needs to be kept in mind, but it's not tested. Next are the 3 A's. These are 3 things that will keep you from getting into court. Again, if the issue is not justiciable, you will not get into federal court. The 3 A's here, the A cubed, are 3 other reasons, all beginning with A's, as to why you might not get into the federal court system. First one is advisory opinions. The court simply was not authorized to give advisory opinions. For example, if Congress is about to pass a law, then it would be convenient for Congress to go over to the Supreme Court and say, "Hi, Supreme Court, we are about to pass this law, and we would like for you to tell us in advance whether or not this law is unconstitutional. Give us some advice." And the courts don't do that. Article 3 of the Constitution establishes the court's authority, and the court has the authority to resolve cases and controversies. Giving advice to Congress is not a case or a controversy, and so the courts simply do not do that. Advisory opinions, no. Also, you run into this problem of advisory opinions sometimes when you have, you can argue when the case that is being trying to be brought before the court is not ripe. Now, if the case is not ripe, that means that the facts which are really constitute the dispute, that the facts have not developed yet to the point where it is clear exactly what the dispute is all about. It's a dispute that is going to happen in the future, maybe, but the facts haven't developed yet. I have a contract with you to build a bridge for you, and it's going to take 4 years to build a bridge. And in the first year of the contract, I say to you, gee, you know, when we get 3 years down the line and get to this point in the contract, we're going to have a problem because of X, Y, and Z. And you say, oh, no, I don't think we're going to have that problem. And I say, well, when we get here, this term should be interpreted in this way when we get here 3 years from now. You say, oh, no, when we get there 3 years from now, this term should not be interpreted that way, should be interpreted a different way. Well, that's a dispute that may occur far into the future, may not ever happen. You can see that the matter is not ripe for decision yet. And that ripeness comes under R here, which we'll talk about again in just a few minutes. But when the matter is not ripe for decision, you might also make the argument that this amounts to an advisory opinion because you are interpreting a contract provision or some federal statute or whatever you're interpreting, that you're interpreting it in the circumstances where you don't have the real facts yet and you're just kind of giving advice. So advisory opinions, courts have no authority to do that. Adequate and independent state grounds. Adequate and independent state grounds, if a state court has made, let's say the California State Supreme Court, has interpreted a California statute in order to resolve some dispute in that court system. And in the interpretation of the California statute, they did not interpret any constitutional provisions at all. The statute doesn't involve any constitutional issues. It just involves some issues of the state law statute. Well, if you appeal that case to the U.S. Supreme Court, there is no federal issue for the court to consider. There's no constitutional issue because the California Supreme Court did not, the case that they resolved did not involve making an interpretation of some U.S. constitutional provision. Maybe they interpreted the California Constitution, but not the U.S. Constitution. So there's no point in bringing that case before the U.S. Supreme Court because there is no federal issue involved. So if the state court decision can be supported by adequate and independent state grounds, where you have not had to use the Constitution at all, U.S. Constitution, there's no point in that case going to the U.S. Supreme Court, and it will not be heard. You see, the cases that sometimes come up there is where the California, for example, has an equal protection clause in its own Constitution. And if a state interprets its equal protection clause in the way that the state Supreme Court says its state equal protection clause should be interpreted, there is no federal issue. Now, of course, we have a federal equal protection clause, but if the state court was not using the federal equal protection clause, they're using the state equal protection clause, the fact that they both use the words equal protection, there simply is no connection between them. However, if the state Supreme Court attempts to interpret its state equal protection law or provision in the Constitution the way the state Supreme Court believes that the U.S. would interpret its U.S. Equal Protection Clause, okay, then the state Supreme Court is trying to do what the U.S. Supreme Court would have done. And if they are trying to make the two equal protection clauses equivalent, so they're trying to interpret the state one the way the feds would interpret theirs, now you do have a federal problem, and the federal courts might very well say, well, no, we would not have interpreted our federal Supreme Equal Protection Clause that way, or we would have. And so if the state case is based on the state Supreme Court's belief that this is the way their decision is based on their belief that this is the way that the U.S. would have interpreted its U.S. Equal Protection Clause, now the Supreme Court would take that case, and you can see why. So in that case, the state grounds are not independent state grounds. They're state grounds which depend on the way the state Supreme Court thought the U.S. Supreme Court would have interpreted its Equal Protection Clause. Finally comes the Abstention Doctrine, which is a third reason that you may not get into the federal courts. The Abstention Doctrine is designed to deal with cases where the state has recently passed a new state law. And the new state law affects some individual, and the individual says, your new state law violates the U.S. Constitution. An individual claims the new state law violates the U.S. Constitution. And so they go to federal court saying, oh, the state has violated my constitutional rights. Well, if you go to federal court saying that the federal Constitution has been violated, that's certainly a reason to be in federal court. Problem is that the state law, let's suppose that this is a relatively new state law, and it has not, and it is possible that this new state law could be interpreted in such a way as to save the state law from violating the U.S. Constitution. Let's suppose that the state law had some term in there that could be interpreted in more than one way. And if you interpret it one way, the state law doesn't violate the U.S. Constitution. You interpret the term in the state law another way, and it does violate the U.S. Constitution. Well, how will that term in the state statute be interpreted? Well, doesn't it seem reasonable to let the state Supreme Court interpret the state statute and see if they can save it first? And so the abstention doctrine, this doctrine right here, says that if this is a state law which has not yet been interpreted by the highest state court, that's the first requirement. Secondly, that it is possible, it is rational, that this state law could be interpreted in such a way that it does not violate the U.S. Constitution, then we should obviously let the state Supreme Court have a shot at it before the federal courts begin to declare the state law is unconstitutional. So the abstention doctrine says, well, in that case, we, the federal courts, will abstain from hearing this case that was brought before us, claiming that your state law violates the U.S. Constitution. We will abstain from hearing this case until you people go over to state court and let them interpret this state law and see if they can interpret it in such a way that will save it. And so what happens in that case is that the federal courts, under the abstention doctrine, do not dismiss. They don't dismiss this case. Okay? Instead, the federal courts will simply abstain, which means that they will stay the proceedings, hold them up, say, wait, hold everything right where it is. We're not going to dismiss you. You people go over to the state courts and get your state court to interpret this law. And when you come back with their interpretation, then we will tell you whether or not the state law violates the U.S. Constitution. That is the abstention doctrine. Now be careful about the abstention doctrine because of those requirements. First of all, you need a law which could be interpreted in such a way that it could be saved. And if there's no rational way to save the state law from violating the U.S. Constitution, there's no point going to the state courts. So first, it needs to be a rational way that you could save the state law. Secondly, there's another provision under the abstention doctrine you need to be aware of, and that is that if this state law impairs the individual's fundamental rights, so that while they are waiting for the state to interpret this state law, they would be afraid to exercise their free speech, their freedom of press, their freedom of religion, the right of privacy, whatever these are. They are afraid to exercise these rights because they don't know yet until you get this ruling from the state court, and that could be a year or more from now. And so you would be depriving this person of the exercise of their fundamental rights while they're waiting to hear from the courts. So in a case where the individual claims that the state law is violating a fundamental right, then the abstention doctrine will not be used. The federal courts will say, well, we're not going to let that happen to this individual, so we'll just go right ahead and interpret this state law for ourselves, even though we're the federal courts. And we will interpret this state law in the way that we believe that the highest state court would have interpreted if they had been interpreting it. So the federal courts then will try to do what the state courts would have done and make a decision in cases where the state law impairs a fundamental right. So that's the abstention doctrine. These are all reasons that you may not get into federal court. Under the, if it is an advisory opinion, the problem here is that Article 3 of the Constitution does not authorize the U.S. Supreme Court to give, or any of the federal courts, to give advisory opinions. You recall that the Constitution, we'll be looking at it more carefully in a few minutes, that the first three articles of the Constitution, Article 1, Article 2, Article 3, Article 1 says here are the powers that the legislative branch of the government has. And there's a whole list of powers in there. These are the so-called enumerated powers in Article 1, Section 8. We'll be looking at those in a few minutes. The enumerated powers. So Article 1 gives the enumerated powers of the legislative. Article 2, the enumerated powers of the executive branch of government. And Article 3, the powers of the judicial branch. And if you look at Article 3, powers of the judicial branch, it does not give the judicial branch the authority to give advisory opinions, but rather gives the authority to give, to resolve cases and controversies. Adequate and independent state grounds, there simply is no federal issue involved, so there's no reason to go to federal court. But here, watch for the question of, is the grounds that the state court used, are they really independent, or were they trying to do what they thought the federal courts would do? And finally, the abstention doctrine, where the federal courts do not want to interpret this new state law. They'd rather the state interpret its own law. But if there's no way to save the state law from being unconstitutional, there's no rational way, then you can throw out the state law. Or if the state law impairs fundamental rights, then the courts will not send you over, the federal courts won't send you over to the state courts because you'd be deprived of the use of your fundamental rights while you're waiting. Those are the three A's. M, mootness. If the case is moot, that's another reason you won't get to federal court. Mootness means that it doesn't matter anymore with regard to the particular case or controversy. It doesn't matter what the Supreme Court decides, it's not going to affect the outcome. It's not going to affect the outcome because it's just too late. One of the famous cases where this happened was in the DeFunis case. This was a case where DeFunis had applied to go to a law school, University of Washington Law School. And DeFunis said that the affirmative action program was unconstitutional because he was not permitted to attend, and that some person who was given special consideration under the affirmative action program that was in existence at that time, and he said that I should have been there in place of this person. Now, DeFunis wasn't being racist about this particularly. He simply said, look, I had better scores than some of these people, and fair is fair. I should have been admitted. This case worked its way up to the Supreme Court, and when it finally got there, DeFunis had been admitted to the same law school a year later, had graduated, passed the bar, and was out practicing law. Should have been litigating his own case before the U.S. Supreme Court. And so in that situation, the court says, well, it doesn't make any difference what we do. This case is moot because DeFunis doesn't have a complaint anymore. So when you've waited too long so that the decision of the court isn't going to affect the outcome of the litigants, the case is moot. It's too late. And of course, there's no point in hearing a case that is moot. E, 11th Amendment. The 11th Amendment is a violation of the 11th Amendment is another reason you may not get to federal court at all. The 11th Amendment prohibits an individual from suing a state in federal court. The states can sue each other in federal courts, but an individual cannot sue his own state or some other state in federal court, and the 11th Amendment says just don't do it. Now, after the 11th Amendment came the 14th Amendment. The 14th Amendment says that no state shall deprive a person of life, liberty, or property without due process of law. And no state shall deprive a person of equal protection of the laws. Well, the 14th Amendment came after the 11th Amendment, and suppose you are an individual and you claim that the state law has violated your equal protection or your due process rights. And the Constitution says no state shall do that to you. And so if the U.S. Constitution says no state shall do that to you, and the state did it to you anyway, where should you go for a remedy? Obviously, you should go to the federal courts. But so you're now suing a state in federal court. Well, 11th Amendment says, nope, can't sue the state in federal court. So what do? Well, the answer is that the 11th Amendment is superseded by well, let's back up for a second. The 14th Amendment obviously came after the 11th Amendment. And as you know, it is a general principle of law that the later law repeals any earlier law to the extent necessary to make the later law effective. So later laws repeal earlier laws to the extent that it's necessary to make the later law effective. So that means that the 14th Amendment repeals the 11th Amendment to the extent necessary to make the 14th Amendment effective. And so as a result of that, if you sue a state in federal court saying that some 14th Amendment right was violated, what the courts will do will say, okay, we will enjoin the state from enforcing that law, or we will declare that the state law is unconstitutional, one or the other. You don't normally need to enjoin a state. You can simply declare that the state law is unconstitutional. You assume the state isn't going to try to enforce it anyway after the Supreme Court has said it's unconstitutional. So you normally just need to declare, the Supreme Court just declare that the state law is unconstitutional. But they could issue an injunction if they wanted to against the Secretary of State or some particular individual from enforcing that law. But the point is that if you claim that the new state law has violated some 14th Amendment right and you go to federal court, your remedy is going to be an injunction or declaratory relief. And that will stop the state from continuing to violate your 14th Amendment right. But you cannot get damages from the state under the 14th Amendment, okay? Because it's not necessary to give you damages for the harm that has already happened to you. It's not necessary to give you damages in order to enforce the 14th Amendment. So you'll get declaratory or injunctive relief if you sue the state claiming they violated your 14th Amendment rights, but you can't get money damages. Ripeness, we've talked about briefly. If the facts have simply not developed to the point where the real dispute is clear, then the matter is not ripe for decision and you'll have to wait. For example, let's suppose that you want to conduct a First Amendment march of some sort, and the city says, and you're concerned that there's some city ordinance that you may violate if you conduct this march the way you want to do it. And so a month ahead of time, you go to the federal court saying, please declare that the city ordinance or the state law or whatever it is unconstitutional because I can't I'm afraid to conduct my march because we may get arrested under this law. Well, the problem with that is that you don't have a march yet. This is a month or more before time for the march. You may not get anybody to come and follow you when you try to conduct your march. So you've got to have, the matter needs to, the facts need to develop much further than that before the matter is ripe for decision. You don't have your people yet, and maybe the city isn't even going to enforce the law. Maybe this is the law. If it's a new law, they're probably going to enforce it, but maybe it's an old law that's been on the books for 100 years and they stopped enforcing it a long time ago, and you're bringing that up. So you see that you got to wait until you get to the point where there's a real conflict between you and the city. It's clear that you got a march you're about to conduct, and it's clear the city intends to enforce this law. Now the matter is ripe for decision, and you can get some relief. You have to wait for the ripeness. Standing. Standing is tested whether the bar examiners ask you about standing or not. You are expected to show that the litigant, the plaintiff in the lawsuit, has standing. Remember that in these con law problems, the state or the federal government is always the defendant. So the plaintiff may be some individual, but the defendant is always going to be one of the governmental bodies, because only the government can violate the Constitution. The Constitution is a document which imposes limitations on the behavior of the government. That's what constitutions do. The government promises its people, we will do certain things and we will not do these other things. And that's what constitutions say. And so only the government can violate the Constitution. The only exception we know of course, is the 13th Amendment against involuntary servitude. But outside of that, only the state can violate the Constitution. And so the state or federal government, so the government is always the defendant. But the plaintiff needs to have standing. They need to be the injured party. The standing, when you, in these con law questions, you should always volunteer, whether you're asked or not, that the plaintiff in the lawsuit has standing and explain why they have standing, and that it is the state who is being sued. When I say state, I mean government, state or federal, that you're suing a governmental body as the defendant. So it's state action. The government did something, and the individual who is suing has got the standing. That's very fundamental to all con law questions, that it is the government who did something that you say violated the Constitution. It was the government who did it, and the individual who is suing has got the standing. You need to volunteer state action and standing. Here, this is the standing, and this one is the state action. Always volunteer these in con law questions, whether you're asked or not. The standing, there are cases where individuals have the standing, an association may have standing, and in a few cases a taxpayer may have standing. And you need to know the rules for standing for each of these. Very important. For an individual to have standing, the rules are that the person who is suing must have an injury in fact, that is, they've actually been injured. Now, in the case where you're seeking declaratory relief or you're seeking an injunction, you're usually doing that before the injury in fact has occurred. And so how are you going to have an injury in fact if you're trying to get a ruling before the injury happens? Well, in that case, the rule is that if you're seeking declaratory relief or you're seeking an injunction before the harm has happened, that the harm must be imminent. Okay, the harm must be imminent. It's about to happen right now. So we need, first of all, for individual standing, injury in fact with that qualification I just gave you. Secondly, redressability. Secondly, causation should be second. Injury in fact, you've been injured. Secondly, causation. Your injury was caused by a violation of the Constitution, causation. And the third requirement is redressability. That is, if you get the remedy you are seeking, it will redress the problem, the injury, or the imminent harm that you're about to incur. So the three requirements for individual standing are injury in fact, causation, and redressability. Associations can sometimes have standing. An association, you can see how the Sierra Club, for example, the Anti-Defamation League, the NAACP, the various other organizations may have standing to assert the rights of their members. There's a famous case in which the NAACP, during the Civil Rights era in the 1960s, where the state, Alabama, I believe was the state, wanted the NAACP to give it its membership list because it said, we believe these people are members of the Communist Party. And the NAACP says, no, we're not going to give you the membership list. The NAACP said, if we give you the membership list, it would violate the rights of freedom of association of the members. It would violate. Now, this is the association saying our members, violating the freedom of association of our members. Well, are you going to let the association sue, or are you going to let them have standing to assert the constitutional rights of its members? Well, the rule is that, actually that was not a good case. That case is better a third-party standing case, and I really should put that, I'm sorry. I'm going to change this a bit here, sorry about that. I'm a third-party standing and taxpayer. And the case that I started out talking with you about just a minute ago, I said I was talking about associational standing. I will come back and talk about associational standing apart. I apologize for getting ahead of myself there. Third-party standing is the one I really want to talk about right now, and I'll come back and talk about that. Third-party standing is the case where the NAACP says, we, the association, we want to assert the rights of a third party, namely our members. They are third parties. We want to assert their rights. They have a right to freedom of association. And if you make us disclose the membership list, then we will be, their freedom of association will be violated because the state is now examining who they are associating with. And so the question becomes, are you going to allow this one person, NAACP, it doesn't matter, it's an organization in this case, you're going to let one person assert the constitutional rights of another and saying, I don't have to do what you, the government, wants me to do because it would violate the rights of some third party. Well, normally you can only assert your own constitutional rights. You know that. And if I want to assert somebody else's constitutional rights, I have to meet the requirements of third-party standing. What are the requirements for third-party standing? The requirements for third-party standing are that I have a relationship with a third party such that that I will be injured if you violate the rights of this person. Okay, I have a relationship with this other person in such a way that if you violate their constitutional rights, I will be injured. Okay, NAACP says we have a relationship with our members such that if you violate their freedom of association, we, the organization, will obviously be injured. Nobody will join. Craig versus Bourne, case where the state had a law that said males who were males had to be 21 years old to buy beer, and females could buy it at 18. Well, the person who owned the bar said, my rights are injured because if I sell liquor to an 18-year-old male, if I sell liquor to an 18-year-old male, I'll get prosecuted. And and my relationship with them is such that I claim that you're violating their equal protection rights. And this statute, I claim, violates their equal protection rights, and I will be injured if I will be injured because of your violation of their equal protection rights. If I sell them beer, I will be injured because of the state's violation of their equal protection rights. So again, the first part of the rule is that the person who's claiming to have third-party standing needs to establish that I will be injured because of the violation of that person's constitutional rights. Those two examples, Craig versus Bourne in the NAACP case. A second requirement for third-party standing is that that person is unlikely, or it's impossible for them to assert their own constitutional rights. In the case of the NAACP case, the individuals who were members in Alabama, if they asserted their own right to freedom of association, it would disclose their membership. And so they couldn't very well assert their own constitutional rights. In the case of the boys who couldn't buy liquor at age 18, but the girls could, what boy in college, or however, wherever they were, this was a college town mostly, what boy is going to take on the U.S. Constitution to get a can of beer? Well, he's better off to get a girlfriend. And so it's unlikely or impossible, improbable, unreasonably burdensome for the boys to take on the Constitution. So the second requirement is that it is unlikely or impossible for the person whose constitutional rights were violated. They are not likely to take the Constitution on for themselves. So in those cases, you can get third-party standing, and those are the requirements for it. Going back to associational standing that we mistakenly were talking about a few minutes ago, in the case of associational standing, the rule is that the association can assert the rights of its members if, number one, the purpose of the association is germane to the purpose of the lawsuit. If you're talking about the Sierra Club and they're suing about the wilderness and keeping it proper and so forth, well, the purpose of the Sierra Club is germane to that lawsuit. So the purpose of the association must be germane to the lawsuit. Secondly, at least one member of the association would have standing. Somebody in your association would have the standing. Some member of the Sierra Club would be injured by whatever the rule is. And the third requirement is that the individual participation is not necessary, is not required, either because of the remedy that you are seeking. It doesn't require an individual participation. If you want to get money damages, you're going to need each individual who's been injured to come forward and say how much I've been injured. But if you're going to get an injunction or declaratory relief, you're going to get the court to declare the state law as unconstitutional, or you get an injunction against enforcing it. If you're going to get injunction or declaratory relief, you don't need participation of the individual members. And those are the requirements for associational standing. Finally, taxpayer standing, that you just don't have federal taxpayer standing. Your interest is simply too minute. To get taxpayer standing, you'll have to show, you almost never have it, and so it's not a big deal. But you basically have to show that, like in a city where the number of people who are being taxed is much smaller, and you need to show somehow that your interest is sufficient for you to bring the taxpayer standing. It just doesn't happen, or is almost never tested. Never tested on the essay part of the exam in any event. So the standing issues, individual, association, and third-party standing are the ones you need to be concerned with. And finally, state action, that obviously if you're suing the government, it needs to be the government who did whatever it is you're saying that's bad. This means that the person who did something bad can be an individual who is an employee of the government, for example, a public school teacher, a police officer, a judge, or if you're claiming that a statute is unconstitutional, the legislature passed the statute, that's certainly state action. And so you need the state doing it. The situations that you come across sometimes raise the question of whether or not the individual who did the bad thing really is representing the state. A real estate broker who discriminates in selling real estate. Well, this real estate broker has a license to sell real estate. And does that make the real estate broker, when they discriminate unlawfully, does that make the state discriminating unlawfully because the state issued the license and the real estate broker is now acting pursuant to the license? The answer is no. That real estate broker is not acting on behalf of the state. The state licensed all kinds of people to do all sorts of things, barbershops, practice law, practice medicine. They license you to go fishing. You need a fishing license. Well, when you have a fishing license, you're not fishing on behalf of the state. Okay, so having a mere license from the state does not make you a state actor, whereas being an employee, like a police officer, for example, or a judge, does make you a state actor. There are some situations, I'm sure you're familiar with, where an individual is acting as though they are the state. You get these cases where the town is owned by the mining company, and everybody who works in the mine lives in this little company town, but the real estate is actually owned by the mining company. And now some religious people come to town and they want to proselytize, go, on the streets and advocate joining their religion. If the owner of the town says, hey, this is private property, you can't come here and do that, get off, you're trespassing. Well, the mining company owns the streets and sidewalks, and the courts say that's a public function, really, streets and sidewalks. And when you engage in a public function like that, owning the streets and sidewalks, that we will treat you like the public. So we will treat the mining company just as though they are the city or state or wherever normally owns the streets and sidewalks, and the same restrictions will be applied to the owner of this company-owned town just as though they were the state. In all common law problems, be sure you deal with standing and state action whether you were asked or not. The other issues you bring up if and only if you are asked about them. People frequently volunteer the mootness and ripeness issues. These two issues here are frequently volunteered, I see, in published answers. That's your own judgment whether or not you want to volunteer that the case is ripe and is not moot. Usually it'll only take you a sentence or two if there's no serious problem there. You may or may not want to volunteer that. But these two, the state action and standing, you should always volunteer whether you're asked or not. Now, that completes our discussion of procedural con law. Obviously, you need to read about these, but I wanted to give you some overview about what each of these elements is about, each of these components of procedural con law is about. Please read them for the details. You need to read the law. We've talked about this before. There's no way in a few hours that I can tell you everything you need to know about constitutional law. So you must do the reading, but reading in the context of an outline of what you're looking for and how the subject matter is put together is much easier reading. But don't listen to this in place of the reading. Please do the reading. Jammers is the mnemonic. We've talked about each of these. Typically, they're worth about 20 points. Now, let me show you a couple of examples where these issues are tested. First of all, the problems which we are using for today are from these three bar exams: the July 96 bar, February 91, and the July 1980 bar. Those are posted and they're also in your 3-ring binder. If you look at the July 1996 problem, we're going to go through this problem in more detail when we look at substantive issues, but I want to show you some examples of procedural con law right now. So if you look at the July 1996 problem, in that problem you recall that Ida wanted to intervene in the lawsuit, and we'll talk more about the lawsuit in just a few minutes. Ida wanted to intervene in that lawsuit, and the objection to her intervening was that she did not have standing. She did not have standing. And so they ask you in that case about the standing. And that would have been worth about 15 to 20 points. She was an individual, so you needed to go through the individual aspects of standing. In the case of the second problem we're looking at today, the February 1991 problem, in that problem they ask you about associational standing. That may the association properly assert these challenges. And so you needed to go through the 3 steps of associational standing in this problem from February 1991. In the question July 1980 problem, you were asked about the Abstention Doctrine. And we'll talk about it in more detail as we get the facts of the problem out. But you see, those are 3 examples where that happened. Now, with that in mind, let us take a brief break, and then let's come back and pick up with substantive constitutional law.